So when we talk about liability and environment, we are essentially dealing with impact of industries on people, property and environment. So first let's try to extend or apply the idea of fault liability in the context of environment. So one of the problems faced, or one of the problems we face when we apply the fault based liability in the context of environment is, like, I mean, in the case of environmental pollutions or environmental degradation, there could be a number of factors, there could be a number of pollutants or number of actors that cause pollution. Or in many cases the peculiarity of environmental issues are such that in many cases it is very difficult to realize the long term and short term implications. Many adverse implications appear quite later on in point of time. And in many cases industries or individuals could be following all relevant rules and still their activities end up in accidents or disasters. In all these cases probably the fault based liability is inadequate to address such situations, or to put it in a different way, there is no good legal reason why victims of such happenings or such industrial accidents should not be remedied. And this is the context in which the idea of strict liability is extremely relevant in the context of industrial accidents and environment. This is particularly relevant in the context of industries that are dealing with hazardous substances, or some industries are inherently dangerous, say for example the case of nuclear power plants. Whatever adequate measures we take, whatever precautions we take, if anything goes wrong, we can easily imagine what kind of implications it can have on the surrounding environment and people. And this is the context in which the idea of strict liability is justified as far as industrial accidents are concerned. In addition to this fault liability and its eventual transformation or eventual development of strict liability, the Indian contribution to this development of liability principle is absolute liability. This was introduced by the Indian Supreme Court in the Oleum gas leak case 1986. And the absolute liability was particularly, I mean, what we can see from the year the case was considered by the Supreme Court, that is 1986. This is just 2 years after the Bhopal incident. Probably the Bhopal was still in the fresh memory of the judiciary, and that resulted in going to the extreme of enunciating a new principle that, I mean, in incidents or in the case of industrial accidents or industries carrying out inherently hazardous activities, I mean, there can't be any room for any sort of exceptions that is applicable in the case of fault based or in the case of strict liability. And this was the context in which the Supreme Court introduced this concept of absolute liability. The meaning is that any industries that are dealing with inherently hazardous substances are strictly and absolutely liable. There can't be any exceptions applied in the case. That means there is no way such industries can take excuse in any matter, including their legal compliance. And later on, this absolute liability principle was reiterated by the Supreme Court in the Bichri case in 1996 also. However, what we can see from the evolution or from the transformation of the liability principle in the context of industrial accidents is there is a gradual transformation from fault based liability to absolute liability. While fault based liability continues to be the dominant rule, strict liability has become the key liability rule in the context of hazardous substances. Whereas, I mean, absolute liability, I mean, even though the Supreme Court enunciated or Supreme Court introduced this principle in 1986, there are very few circumstances in which this principle has been applied in a real life situation. So the actual rule is, while fault based liability continues to be the rule in the ordinary circumstances, as far as hazardous industries or hazardous exceptional circumstances are concerned, the strict liability remains the rule in the context of liability. Now let us look at how this idea of liability has been incorporated in environmental laws in India. First, let us start with this absolute liability. It is very difficult to find the explicit recognition of absolute liability in environmental laws in India. However, the judiciary has applied, or judiciary has not been reluctant in applying the principle of absolute liability in a few circumstances, although it is not in many circumstances that the judiciary has applied it. For example, one of the latest example is in the Sterlite case decided by the Supreme Court in 2013, while asking the sterilized industries to pay a 100 crore compensation, the court referred back to the 1986 decision in the oleum gas leak case. So apparently, I mean, this is one of the few cases where absolute liability has been referred and mentioned and apparently used by the judiciary. And the second principle, strict liability, that continues to be the major statutory expression in the context of hazardous industries and industrial accidents, because there are several statutes that endorses strict liability as the applicable principle in the case of industrial accidents and hazardous industries. So what we can see or what we can conclude from this examination is, like, I mean, legislative intention is apparently goes with fault based liability as a general rule in the case of so called ordinary circumstances, whereas strict liability is the dominant rule as far as industrial accidents and hazardous substances are concerned. So just to cite two examples where this principle of liability has been incorporated in the environmental laws in India is Public Liability Insurance Act 1991. And this statute explicitly endorses no fault liability, which could be taken as endorsement of the strict liability principle in the case of industrial accident. It is pertinent to note that this Public Liability Insurance Act 1991 is a statutory framework to provide compensation in the case of industrial accident. And the statute explicitly says that the claimant need not prove any wrongful act, neglect or default of any person. That means the claimant just need to provide or establish that the victims have suffered injuries, and they need not explain or need not establish that the other party has committed some error, or the other party has violated any environmental law provisions, or the other party has been in breach of their legal duty. Another example is perhaps the recent example is the National Green Tribunal Act 2010, and in the case of even in this statute, which explicitly endorses this no fault liability in case of accidents. So while this is the expression in the environmental laws in general, or the environmental statutes, so we also need to understand what is the scope of liability in this context. What is the scope of liability in the context of industrial accidents? So first, the pertinent question in this regard is liability for what? So what the answer we get from environmental statutes, whether it is Public Liability Insurance Act or the National Green Tribunal Act, what we get is that liability, the scope of liability is, or the liability is applicable in the context of death or injury to people, damage to property and damage to environment. While there is a small difference as far as Public Liability Insurance Act is concerned. For example, in the Public Liability Insurance Act 1991, the environment is missing. That means the statute has not included environment within the scope of liability. It only mentions death or injury to any person or damage to property. Whereas the National Green Tribunal Act 2010 is comprehensive in this respect, that it includes both death or injury to any person, damage to property as well as damage to environment. In this context, what we can say is like this is more comprehensive in terms of bringing, or more comprehensive in terms of the scope of the liability. Now, let's try to understand the major schemes envisaged or designed under the Public Liability Insurance Act 1991. As I have already mentioned, the Public Liability Insurance Act 1991, the object of the act was to provide immediate relief in the case of industrial accidents. And that means the idea behind the Public Liability Insurance Act was not to exclude the victims from approaching any other court or any other forum under any other law. And the idea was not to exclude remedies available to victims under any other law. But instead, the idea was to provide immediate relief, probably not to let victims to wait for long to get immediate reliefs. In this case, I mean, a major innovative idea introduced by the Public Liability Insurance Act 1991 is to make insurance coverage mandatory for hazardous industries. That means all hazardous industries were supposed to take insurance coverage, and the power to decide the liability issue was vested with the district collector. And in this case, it is very interesting to note that this was not or the collector was not acting as a court in this case. The collector has a proactive role to play as far as determination of liability and determination of compensation is concerned. The collector was supposed to hear the claims, and the collector is expected to conduct an inquiry into the claims in this context. So that means whenever an industrial accident occurs, the collector is expected to invite claims from the victims, and the moment the victims submit their claims, the collector is expected to conduct inquiry from his own side. So this means the burden on the victims is much less when compared to a contentious case before a court of law. And here I mean this is understandable because when the victims when they have already suffered injuries and damages, so it's a positive contribution from the part of the law that I mean the existing institutional mechanism, say in this case the collector is taking proactive initiatives in terms of fixing liability and compensation. And in this case, whatever the award decided by the collector, and the money has to be paid from the insurance amount. That means the insurer, it is the duty of the insurer to pay the amount. And whenever I mean there is a if the award is beyond the insured amount prescribed under the Public Liability Insurance Act, the rest of the amount has to come from a fund called Environment Relief Fund, which is supposed to be established by the central government. So there is, and what we can see is that there is a two-tier mechanism prescribed under this statute, that I mean the first set of compensation is expected to come from the insurer, and if that is not adequate in terms of covering the compensation, or that is not adequate in terms of compensation, the rest of the amount is supposed to come from the Environment Relief Fund to be established by the central government under this law.